All right, why don't we kick things off right now? Good morning, everybody. My name is Ben Slang, and I'm a Membership and Business Development Associate here at the Digital Supercluster. And I am pleased to welcome you all to our webinar, AI, Ethics and the Law. So before we get started, we respectfully acknowledge that in Canada, we live, work, and learn on the unceded traditional and ancestral land of Indigenous peoples. As myself and most of the Digital Supercluster team is based here in Vancouver, British Columbia, we are gathered on the traditional ancestral territory of the Musqueam, Squamish, and Tsleil-Waututh peoples. And we encourage you to take a moment to acknowledge and consider the traditional territory that you are joining us from. As a reminder, this webinar is being recorded and it will be distributed to all registrants afterwards. If at any point during the session you do have a question, please type it into the Q&A box at the bottom, and we'll address them during the end of the Q&A portion. Excellent. Off to you, Jen.
Thank you so much, Ben. Bonjour, everyone, and welcome. It's wonderful to have attendees joining in from across the country and across the superclusters in the first of 2023's IP-focused monthly sessions, and kicking off this new year with AI and data, very top of mind. Stay tuned for more on our next month's webinar around data collection, ownership, and licensing, scheduled for mid-February. Whether you're new to the supercluster or a returning face, we're thrilled you could join us for this Power Hour. Next slide, please. Canada is no stranger to AI, having been the first country to release a national AI strategy and its leadership in AI excellence. And whilst there is a lot of promise of what is possible, it is also sparking broader concerns of the need to understand relevant ethical considerations when developing for AI. With the rapid adoption of AI, there is increasingly a greater concern around the ethical use of AI, requiring organizations to adopt an ethical framework to inform that development and responsible use. A failure to do so puts an organization at risk of reputational harm as well as potential exposure to liability. Over these next 60 minutes, the discussion will look at considerations for developing an AI ethics framework, the risks associated with failing to develop an ethics model, and legal and ethical things you need to consider when developing AI systems. And we encourage you to post your questions in the Q&A you'll see at the bottom of your screens. Next slide, please. Fundamental to the global innovation clusters is collaborative innovation, setting the framework for projects that address cross-industry challenges while creating technology products that can scale across industries and ultimately across the world. Digital's IP strategy supports the development, ownership, and retention of Canadian IP through a number of vehicles, and informational sessions with thought leaders like we've today are one example of that. Next slide, please. I have the pleasure of introducing two esteemed thought leaders with us today. Please join me in welcoming Barry Suckman and Carol Piovesan. Barry is Senior Counsel with McCarthy Tétrault, Toronto, and formerly co-chair of the firm's Technology Law Group and head of the Internet and Electronic Commerce and Intellectual Property Groups. He is one of Canada's foremost authorities in the areas of information technology, intellectual property, and privacy anti-spam law, and consistently ranked nationally and internationally amongst Canada's top IT, IP, and privacy lawyers, and a published author and adjunct professor teaching intellectual property at Osgoode Hall Law School. As lead lawyer in Canada's biggest and most complicated domestic and international outsourcing and cloud computing deals, Barry has also appeared in the Supreme Court of Canada, testified numerous times before parliamentary and Senate committees on intellectual property related issues, and advisory member at leading associations and think tanks that include PTIC, TechNation, the Copyright Society of the USA, LES, McDonald-Laurier Institute, and the Center for International Governance Innovation. Carol is a managing partner at INQ Law and global leader in artificial intelligence. She practices in privacy, cyber readiness, data governance, and AI risk management with a focus on ethical AI and responsible innovation. A seasoned former litigator and data co-lead for a national firm, Carol has testified before the House of Commons Standing Committee on Access to Information, Privacy, and Ethics, and has been involved in multiple data governance committees for the federal government, national sector committees, the Global Partnership on AI, an international 29-member country multi-stakeholder initiative that aims to advance the responsible and human-centric development and use of artificial intelligence, and acting as advisor to several AI companies. She is co-editor of a recently released book, Leading Legal Disruption, Artificial Intelligence and a Toolkit for Lawyers and the Law, and an adjunct professor at University of Toronto's Faculty of Law, where she teaches on AI law and policy. We are in for an amazing next power hour. And without further ado, Barry and Carol, I hand it over to you.
Thank you so much for that introduction. I'm going to kick it off and then I will turn it over to Barry. So I'm going to start with a discussion about sort of contextualizing AI ethics in a really, we're going to start sort of philosophically and then get really practical quickly. And then I'll turn it over to Barry to survey some of the key laws that we see emerging and what are the implications of those laws. So as a starting point, next slide, please. As a starting point, the capabilities with artificial intelligence are becoming better and better known. And there is much more interest about AI and the use of AI than ever before. I have to say this morning when I was looking on my LinkedIn page, which if you are connected to me, you'll know I do that often. I saw somebody post something that, 10 years ago, we used to say, oh, well, there's an app for that. There's an app for that. There's an app for everything. Well, today, this was a marketing executive who posted and said, there's an AI for that. There's an AI for everything. And increasingly, we can see that that is true with the excitement around Chat GPT, excitement and some trepidation, I must say, growing discussion around self-driving cars, the use of artificial intelligence in facial recognition, the use of artificial intelligence in chatbots and virtual agents, something that our own federal government employed at a certain point during the COVID crisis, in particular, experimenting with different techniques. We see that some of the real benefits of AI are these ability to analyze a huge amount of data and then identify predictive patterns, trends, and outputs that can be more consistent, more efficient, more effective, drive better decision-making, and more valuable insights. Really, from an economic perspective, we're not only seeing some of the benefits of AI in what we do, so allowing each of us to sort of play to our strengths and to our highest value, by getting rid of some of those repetitive tasks, but also a really competitive commercial landscape with an estimate of 15 trillion to be included and contributed to the global economy by 2030 from AI alone, defined very broadly. So moving to the next slide, one of the big issues, though, and it's a legitimate issue, is that there is significant public distrust in these technologies. So if you're in the space using, building, developing, exploring, experimenting with artificial intelligence technology, it's really important to understand the context. And this is not only important from a reputational perspective, but as you'll see in the latter part of this presentation, it's incredibly important from a compliance perspective. So increasingly being able to understand the context in which your system will be used, the potential impacts on individuals, some of the deficiencies, weaknesses, or lack of validation in your data sets and in your models. These are important considerations. They're driven in part by a lack of trust in these systems. And so being mindful of the transparency function that you need to bake into your broader AI governance program is really critical. So this poll in particular, looking back at EU and US public opinion, shows that a vast majority of those polled feel that AI systems ought to be carefully managed. And this might give us some insight as to why we see so much regulatory activity, particularly in the last 18 months, around standards, guidance, best practices, and increasingly emerging law focused on risk mitigation of particularly high-risk artificial intelligence systems. So moving to the next slide, what has emerged over the last few years in particular is an entire field around AI ethics. And in my class where I teach on AI regulation, I often have to step back because there's so much chatter about artificial intelligence that I often want to just step back and say, okay, well, what are we talking about? Like, why are we talking about this? What are the issues? So where we have seen artificial intelligence used in various circumstances, Public sector in particular has raised a number of flags: use of artificial intelligence in the criminal justice system, use of artificial intelligence in border security, same in various interactions with the federal government, whether it be through benefits and claims uses. That the fact that we are using these systems that are processing all of this historic data raises a number of concerns around what the outputs of these systems produce and the implications of those outputs. And so where we see the field of AI ethics emerging is really to look at both the moral code associated with these technologies, and then what are the duties and obligations that align with some of the concerns that we have and the potential harms that we identify. So what are some examples? Well, what we'll see in the next slide, although we won't go there quite yet, what we'll see there in the next slide is that through various discussions, civil society, industry associations, government groups, private sector involvement, through a number of experimentation, case studies, research, uses of artificial intelligence, contemplating these potential harms, there are a number of concerns that are raised to do with the data sets. So do we appreciate that the past, the data of the past, is not necessarily what we want our future to look like? So are we cognizant of the data that we're using to process in these technologies and what that impact could be on our future? I'll give you one quick example from the health sector. There was a study that was produced not long ago identifying a real discrimination in a triaging algorithm that was used to identify services in the health sector in the US for a particular health entity. And in that triaging, what it found is that the algorithm was favoring healthier, wealthier white men over poorer, sicker Black men. And the reason, when they looked into, part of the reason associated with that study was that the historic data was favoring, it had a greater data set for the wealthier, healthier white men who were accessing the health services more readily than their counterpart. And as a result, the algorithm trained on that data set that had not identified the discrimination in the data set in advance was actually harming individuals on the output side without there being sufficient understanding of how the system produced that particular output. And so that's one example that I flag in the context of ethical AI, because that's exactly the sort of situation that not only best practices and standards and guidance, but also the law is trying to prevent. It's trying to create a greater degree of accountability associated with those potential harms. So now we will move to the next slide. And I recognize that it is microscopic in scope. So I don't really anticipate that you'll be able to read all components of the slide, but I do think it's sort of visually interesting to see what it looks like to sort of pinwheel all the studies that were looking into ethical AI and principled responsible AI leading up into the 2020s. So that's okay. Before we get there, I'll sort of describe it for you, and then when we get there, we'll sort of look at it in detail. But dated, but that really tried to assess all the various frameworks to do with responsible and trustworthy AI to identify consistent and key themes. And I want to flag this for you, because what you're going to find is those key themes that were identified actually carry forward time and again through various principles and best practices. And what I will suggest to you is that these key themes carry through to what your AI governance program is meant to look like. So really trying to get practical in the end. When you see these key themes, each of these themes are being baked into the law, and you will see that in Barry's presentation. They are being baked into requirements of the law. They are informing the ethos of the law associated with artificial intelligence. And increasingly, they are forming that foundation of what a practical, operational AI governance program ought to look like. So looking at this particular pinwheel, which, as I admit, is microscopic, what is visually interesting to me is the extent to which there have been a number of studies to do with artificial intelligence. And again, if you go back to this notion of ethics and public distrust and the real strength and force of this technology, you can understand why there is so much attention associated with the harms contributed by this type of technology, and the fact that it is a technology that will not necessarily be well understood by the layperson, though can be extremely persuasive in its outputs. And so some of the key themes that were reflected in this particular study and that you will see carry forward are human rights and human values. So are these systems aligning to our human rights and human values? And how do you prove that? How do you establish that? How can you show that that's the case? We have themes of professionalism. Are the appropriate developers with appropriate expertise developing these systems? And do you have that same kind of oversight through verification mechanisms, whether internal or external, that are able to look at those systems and determine whether they are robust, secure, accurate, reliable? We see human control, this notion that we don't want to have a technology run away from us, so to speak, but that there are interventions that can be had in order to protect the intended purpose of the technology and ensure that it is appropriately used. There, you'll see notions of fairness and non-discrimination, a key component of an AI ethics agenda, and ultimately a key component of your compliance program. So we see laws like New York Local Law 144 that in the employment sector is requiring any system that is used in employment and recruitment, where there are some caveats there, but any AI system used in those contexts, that they have a bias assessment associated with them, and that there's a public notice so that the individual can understand if their rights may be implicated in the use of that system. We see notions of security and safety to protect the system, particularly those that may be vulnerable to adversarial attacks and can have various impacts on individuals. We see accountability and privacy as core principles as well. And so moving to the next slide, where we look at what I can describe as probably the most persuasive set of principles of sort of internationally recognized AI principles. The key components are highlighted in blue. And what they show is, and you'll see this pattern of thought, but you'll see that the OECD countries agreed on principles to do with driving inclusive growth, sustainable development, and well-being, that AI systems are designed to respect rule of law, human rights, democratic values, and diversity with appropriate safeguards put in place, that there is a degree of transparency and responsible disclosure around AI systems. Keep these in mind. I want these to inform what your compliance program is going to look like, and I want you to see them in the law. That AI systems have to function in a robust, secure, and safe manner that are continuously assessed and managed. So this iterative process to your assessment and compliance program, this iterative process to your AI governance program is really critical. And then finally, that there is accountability in place. And something that you'll find just this morning, we had the National Institute on Standards and Technology in the US present on its AI risk management framework, really aligning itself to other sort of global principles, including the OECD principles and recommendations, including the EU AI Act that Barry's going to talk to you about, as well as the US sort of draft Bill of Rights of AI rights. Draft Bill of Rights for AI systems. And then you also see various ISO standards that are coming up. And so we really feel this connection between these various principles and what the articulation or the prescription of those principles look like. If you go back to that sort of conceptually to that slide on AI ethics. And so moving forward, the international trends in AI regulation is that, in the last year and a half, we've seen some of the biggest advances in AI and machine learning regulation around the world. So every major economy in the world has an AI strategy, and the EU, US, Canada all have proposed laws on artificial intelligence. China and Brazil have actually passed laws on artificial intelligence. And what you'll see in Barry's presentation is how advanced the EU AI Act actually is in not only being prescriptive in terms of what it expects in terms of accountability, but in aligning to some of those ethics principles that we've already talked about, so that you have a clearer picture as to what you could start doing today to prepare for that regulation of the future, whether it's passed tomorrow or it's passed in 5 years. Recognizing that trust deficit in AI systems, recognizing some of the core ethics questions that are being raised, and then connecting all of those dots to even the proposed regulation, it starts to inform exactly what your compliance program ought to look like. And so in the US alone, in 2021, we saw 130 different AI bills proposed and some passed. We've seen this at the federal level, the state level, and even the city level. You can imagine the level of fragmentation we may be facing if we end up with multiple levels of AI regulation that are not only across the technology, but sectoral focused as well. We've also seen Singapore piloting its AI Verify, which is a trustworthy AI framework. Anybody can go access it, anybody can pilot it. And what they're trying to do is establish that case study and the process that they've put in place through the AI Verify framework as a basis for what their future regulation might look like. And in addition, we've seen regulatory sandboxes emerging, UK and Spain sort of leading on examples. Moving to the next slide, what's playing a really important role is the standards that are being set on artificial intelligence. So as I said, NIST today announced that NIST has been in consultation on its AI risk management framework for a while. Today, they've put out their playbook, they've put out their roadmap, and there's still room for consultation. So if you have some thoughts, I'm sure they'd love to hear from you. And they also have their program for what responsible risk management framework and AI risk management framework ought to look like. You will not be surprised by the themes. The themes are consistent with the ones that we have covered, focusing on areas of fairness, security, safety, privacy, robustness, explainability, accountability. So these themes are consistent across the standards. But what is coming out and what you should see in the next year for sure is the ISO standard for a management system, for the AI management systems. And I want to highlight this one for you, because if the EU AI Act passes as we expect it to, there will be, for high-risk AI systems that Barry will talk to you about, there will be a conformity assessment that is required in order to have that product enter or be used in the EU market. And the ISO standards will align with EU standards to help give us guidance as to what the benchmarks are for a responsible, appropriate AI system or high-risk AI system into that market. So these standards are really important because they're serving as the sort of benchmark of how the regulation will be either applied in some cases or interpreted, or access points in order to enter certain markets, such as the EU market. I want to close my particular part on the next slide that focuses a little bit more on operational considerations. So the diagram you have to the right is taken from the NIST framework, and it is very high level. But again, once we start looking at some of those ISO standards, and you actually just step back, listen to Barry, listen to the various criteria that you see being baked into the laws across different jurisdictions, and you will see already what needs to go into your AI governance program. So, the first thing I always say is you already have a strong foundation. If you are a data-rich organization, and I would be shocked if any of you are in the audience and you are not considering yourselves a data-rich organization, then you already have a strong foundation. So build on that data governance foundation. If you don't have a strong data governance foundation, start there, but build on that foundation and grow your AI governance program. I call it AI governance. It may be AI management. You could call it AI compliance in the end. It doesn't really matter, but there are a few key features. The first is that you are going to be required to demonstrate data testing and validation, particularly for bias and non-discrimination. You will be asked to demonstrate in high-risk systems that you have conducted an impact assessment, and in certain instances that you have conducted stakeholder engagement. And you can draw from the federal government's algorithmic impact assessment for some inspiration as to what an impact assessment will look like. But ISO will also come out with some standards to help give that guidance. And you can look at the AI risk management framework from NIST as well. There will be AI risk assessments that need to be conducted periodically. In some cases, it's annually. In some cases, it might be something else. And there will be a requirement for some degree of model validation, whether that's internal or often it's seeking sort of external approval of the model. There will need to be an incident response plan for where your AI systems that you are responsible for, and there's a whole discussion about that for sure, but where they're starting to not be used for the appropriate intended purpose, or where something goes really wrong and there has been a security breach of that system. And then finally, there are a series of policies and procedures that try to promote safety, iterative oversight, disclosure and notice, human control. And so closing on the last slide for my part, some examples of what these considerations or policies may look like. You'll see, for instance, an explainability policy. And really that means if you need to explain how the system produced a particular output, are you able to do so in a manner that is interpretable or understood to the layperson? There may be an automated decision system inventory that is required. And in that case, we're seeing this under the Canadian privacy law that Barry will speak to. We see it in other contexts as well in the EU AI Act, where an inventory of these higher risk systems are required. We see transparency policies that are required as well, and an entire program around how you build that transparency. Human intervention is another requirement that we see time and again in certain instances. What will the intervention look like and who will have it? What does the ongoing monitoring process look like for those systems? What does the incident response process look like? And then specific considerations around vendor management and vendor assessment, as well as internal AI standards that your organization is holding itself to. So with that, I will close and turn it over to Barry to discuss the law.
Yeah, thank you very much, Carol. And Jen, thank you very much for the introduction, and hi everyone in the digital ecosystem in the supercluster. I know Carol and I are very excited to be here with you, and we know that you're in the middle of a vortex with technology changing, ethical principles being thrown at you, and a whole bunch of regulatory developments. And it really is difficult, particularly for Canadian organizations, I think, to get their heads around where everything is. I want to kind of give you my take on where I think we are. And you'll see throughout the slides, I've got some quotes from, the modern Oracle, which is OpenAI. It used to be, Greek time, you might go to an Oracle, then eventually we evolved to libraries and Google. And now, of course, we're all looking at probably a more intelligent way of presenting information. The way I see it is we're moving into a legal landscape where there are a whole bunch of existing laws and regulations that govern product safety, that govern bias and discrimination. But we're faced with challenges of understanding the rules of the road that are in part based on ethics, part based on law, part based on what's needed for AI to really promote innovation. And if you go back probably the early 1900s and you see this Model T, When this was introduced, there were no rules of the road. You didn't know if you had to drive on the left side or the right side. And of course, we agreed it was the right side. UK agreed it was the left side, and we ended up trying to to figure out more rules of the road, like stop signs and lights and a whole series of legal machinery around the car, including duties of care, insurance products, right? This was revolutionary and caused real rethinking of legal infrastructure. And I think we're at the Model T level, although there's areas, as Carol has mentioned, in terms of development of standards and governance frameworks, and we're progressing with respect to areas like privacy. But I think we're still at a very early stage. And we need to be really thinking about the way our regulatory frameworks are going to work, because they will seriously impact your businesses and how Canadians are able to innovate. And it's a still open question whether the AI regulation is going to follow the economics or not. There's a very good book that maybe some of you've read, maybe you haven't, Power and Prediction by Professor Agrawal from Rotman. And he looks at the economics behind different AI solutions, including point solutions where you just drop in an AI into existing system and it fits in, somewhat the way our current, say, autonomous vehicles are going to fit into the current rules of the road, and system changes whereby the rules of the road have to change or could change in order to promote innovation, in order to seriously get the benefits of artificial intelligence. Some countries like the UK and Israel are developing sectorial approaches to regulating artificial intelligence, so that they can look at not only the key areas that Carol focused on, which is making sure that they comply with key principles such as safety, robustness, avoiding bias and discrimination, which are clearly important, but also put the AI systems within a regulatory regime that is intended to look at not only these problems, but also the way the law needs to be innovative or rewritten on a systemic level in order to work. And I think the way we're progressing in Canada is taking a point solution to regulation rather than a system perspective, because they're taking a horizontal approach rather than a sectoral approach. And I think that's going to affect a lot of your businesses, because I know that you're often bumping into existing laws and trying to make things work within a framework. And we need to address both point solutions, and we need to address system solutions, which I know is important to a lot of you. I don't think we're going to expect anytime soon any real convergence or agreement on exactly what the regulatory frameworks can be. There is discussion in the European Union on a possible treaty, which most likely is going to deal with the use of AI in the public sector. At least it will if the US gets its way. And so I think we're going to see developments that deal with the use of AI in public sector, to deal with all the things that Carol was talking to you about, fundamental rights, including border controls, government benefits, those sorts of things, but very unlikely to see it at the international level. With that said, there's collaboration between the United States and Europe going on, but a lot of that is dealing with standards rather than the specifics of the regulatory frameworks. The one area that there has been developments in, particularly in the European Union, are with respect to the regulation of privacy. And in particular, there are some specific developments dealing with artificial intelligence systems. And what we're seeing under the GDPR are standards that deal with anonymizing personal data, which is absolutely critical, right, to the ability to access data in order to train algorithms. And the EU has a standard that says that anonymous personal data is outside of the GDPR if it's unlikely that a data subject will be identified. So it's not a stringent, I mean, it's a very tough test and it's hard to apply, but it's a foreseeability test. And that is helpful for organizations in the GDPR who need to anonymize data. And it also, of course, helps sharing of data between organizations. There are three specific things that you need to know about under the GDPR, particularly if you're ever going to be marketing your products in the European Union. The first is that data subjects have the rights not to have a decision being made affecting them in certain cases. And if it's a decision which produces legal effects or similarly significant effects, then there is a right that individuals have. This was a landmark development by the European Union. And I think the thought was very much in the context of the public sector, but of course, this applies to the private sector as well. They've also implemented the AI ethical principle of transparency, so individuals should know when a artificial intelligence system is being used. And then there is an explainability obligation. There is hefty debate in the European Union as to whether the explainability obligation extends to giving individuals the actual reasons why a decision was made about them, or whether it's a more higher level obligation to be able to explain the nature of the system, the key determinants and parameters to decisions that are made against individuals. The better view, I think, of the leading data protection authorities in Europe is that it's the latter and not the former, which recognizes that while organizations can understand at least significant reasons why an algorithm makes the decision, sometimes there's things that even the developers don't know, and that's how AI works. And that seems to be the predominant view. Canada is moving ahead to replace our national federal privacy legislation with PIPEDA by an act which let's refer to as a CPPA, but it's also introducing a new Artificial Intelligence and Data Act, being AIDA. So we have parallel developments going on in Canada, both on the privacy side and regulations that are specifically going to target the development and deployment of artificial intelligence systems. On the privacy side, our law, should it be enacted in this form, will not have a right for an individual not to be subject to an automated decision. And if we had more time, I'd give you kind of my views, but I think at the end of the day, given this is a private sector law, I think that decision that the government is making does make good sense. But the way they've handled the question of when data becomes anonymous and the transparency and explainability obligations are creating standards that would be even higher than those in the European Union, which will make our laws interoperable. On anonymizing data, it has to be irreversibly and permanently modify personal information in accordance with generally accepted best practices to ensure that no individual can be identified, whether directly or indirectly. Nobody knows exactly what that means, but by talking about generally accepted best practices as opposed to the reasonable, foreseeable, or expected standard, it is higher than the European Union, higher than other standards in other provinces in the country, and so that is going to be difficult. And given the clear and present problem that Canadian organizations have to be able to access data in order to train algorithms, having a test that is a higher and more difficult test to standards seems like a potentially problematic regulatory policy. On transparency and explainability, the transparency obligation is one, I think, that's straightforward, but the explainability obligation again seems to be out of step even with the European Union. When you look at the wording, particularly in the revision to the bill, the standard appears to be that individuals going to be entitled to an explanation about why a particular decision was made. And we all know that that's going to be more challenging. In terms of the U.S. approach, while there are a zillion bills in the United States, federally, the U.S. has not enacted any legislation. There's currently no legislation that's pending. The FTC has said that their jurisdiction does apply, particularly with respect to algorithmic discrimination. Other regulatory authorities are saying that their laws can apply as well. Carol's right. There are some specific state laws that are coming into force, particularly related to employment standards and biases. They are taking a much more hands-off approach, which some commentators say is reflective of their more kind of laissez-faire attitude towards regulation of technologies. The only significant step, again, leaving aside all the work they've done on the standard side and governance frameworks, I'm talking about in terms of the law, is the White House AI Bill of Rights, which pretty much is consistent with the OECD and other principles that Carol was telling you about. It doesn't have the force of law. It's not even official US or White House policy. Carol referred to the EU AI Act as being an initiative in the European Union that's moving ahead. And she was quite right to tell you that you really need to keep an eye on what's happening in the EU, not only because you might have systems that actually fall within the regulatory frameworks, but because of the governance frameworks that are built into the AI Act that are frankly good business practices. The way the AI Act is going to work is that they regulate systems based on risk. There are some that are simply prohibited, like social scoring and real-time biometric ID systems in public spaces. And then there are those that are a high risk. And the high risk really fall into two categories. The first is certain products are already regulated under various EU directives, and those are going to fall into the high risk category. And in some respects, they're going to be regulated under the existing, or at least in some respects, under the existing regulatory regime. So they're taking partly a sectoral approach to regulating existing products that are going to use AI. And then there's about a dozen others that they've added, many of which you will see fall within the public sector rather than the private sector. So some of them, like remote biometric ID systems, would be both. You could see critical infrastructure as being public, education, workers management, and access to essential services, administrative of justice. So their act is meant to cover not just private sector, but also public sector. So it's much, much broader than what Canada is currently contemplated. And then there are those that are limited risk, where there's certain transparency rules. The main regulatory provisions apply to those that fall into the high risk system. And these are ones that you really want to pay attention to because they're good business practice, and they may well find their way into regulatory regimes in other countries. And so these are some of the things that Carol was talking about. Having a good risk management framework, must be tested, have to have very good data and data governance focus to make sure your data meets special or specific qualified criteria, technical documentation, and then recording of logs to be able to determine whether the system is operating as appropriately. And then I've put this one together, but it's actually, there's actually multiple different paragraphs dealing with this. They've got to be designed and developed so their operation is transparent, so users can understand and use the system appropriately, can be effectively overseen by natural persons, when in use, achieve an appropriate level of accuracy, robustness, and cybersecurity, and perform consistently in those respects throughout their life cycle. So many of these principles you will also be familiar with if you've looked at the AI governance documentation that Carol was talking about. Make no mistake, the EU laws have what people refer to affectionately as the Brussels effect. Other countries want their citizens to be able to do business in the EU, and therefore take a very, very close look at what's going on in the European Union, and their laws, like the GDPR, has had enormous effect. And so these are things, if you're going to be doing business worldwide, you really have to keep an eye on what's going to happen with the EU AI Act. Canada has, as I mentioned, new legislation, which is currently in second reading before Parliament has not yet gone through a committee, and it has lofty goals. And the question for many is whether it's going to achieve these goals. But it does focus on mitigating risks of harm and biased output. So two key lenses to think about: risks of harm, including safety, and biased output, think discrimination. The obligations are on an individual who's responsible for an AI system to assess whether it's a high impact system, and if it is, to identify, assess, and mitigate the risks of harm or biased output, and then establish measures to monitor compliance with the mitigation measures and the effectiveness of it. And if it is high impact and there's a problem, to let the minister know. Now you see, all of these things are all defined in regulations. So I'll show you the high impact system definition. It's all a definition. We have no idea what it is. And then in terms of establishing measures, all in accordance with regulations. Monitoring compliance, all in accordance with the regulations. This legislation is really a skeleton for the development of a law. And kind of my view is it's such a high level skeleton that organizations can't really tell what is going to be regulated. If AIDA was evaluated like an AI system, one would probably say it would fail because it's not transparent in terms of what it covers. It lacks explainability because you can't tell how it's going to work, and you don't know if it's going to be robust enough. In terms of what it will cover, because the definition of artificial intelligence is autonomous or semi-autonomous, and the definition of harm is really any harm without any scintilla of qualitativeness, this legislation could theoretically cover just about anything. It could cover, the more dangerous concerns that Elon Musk and others have. It could cover maybe biometric systems and facial recognition systems. but it could even cover OpenAI, which is being used now to write malicious code and to use that to attack systems. But it's so broadly worded. It would even catch robotic vacuum cleaners that knock over a plant and break the pot. The legislation is sweeping in terms of who it could potentially apply to. It can apply to anyone that designs, develops, or make available an artificial intelligence system. It could also apply to anyone that makes data available for use in an artificial intelligence system, or anyone who anonymizes data for use in an artificial intelligence system. If it applies to everyone and all the obligations apply, it's quite imaginable that is going to create a huge problem of compliance. If you look at all the AI actors in the ecosystem, and you know them well, right? It's possible that every single actor involved in the development, deployment of AI system is going to be caught by this legislation. What we don't know is how the regulations are going to be drafted to understand what responsibilities individuals that make algorithms will have versus someone that designs versus someone that makes the system available for deployment. And that is causing a considerable amount of uncertainty because nobody knows what this legislation is going to cover and how the regulatory regime is going to work. And there are quite extensive enforcement powers that ISED will have, including order-making powers to order on a high-impact system simply to cease using it if the minister has reasonable grounds to believe that there's a serious risk of harm. And the sanctions and offenses are quite large. We don't know what the administrative monetary penalties are going to be because those will be established by regs. Another thing we don't know, but we know that the fines for violating this could be $10 million or 3% of the person's gross revenues, which is ever higher. And these penalties are far higher than penalties for violations of the Food and Drug Act or the Canadian Product Safety Act, which means that if you kill someone with a molecule, your potential risk is way lower than if you cause harm using an artificial intelligence system. There are, I think, some very significant problems with AIDA. I'm going to be publishing a blog probably on Monday for those who are interested in it. But to go back and kind of finish off the way Carol did in terms of governance, I'm providing you with a dozen or so suggestions as to what you consider doing for governance. And rather than kind of list what you normally see as governance principles when you look at AI ethics or look at governance practices, what I tried to compile here are the kinds of things you will need to consider in a governance framework, having regard specifically to what the AI Act is going to require and what it looks like will be required in Canada for high impact systems. And so you can take a look at this. And I think you got to keep an eye on what happens in the EU, including because of the Brussels effect. You've got to look at what's going to happen in Canada under AIDA. And you have to keep a look at best practice standards and governance frameworks, as Carol mentioned to you. The one thing I can say to you is that AIDA is not baked in stone. We know the government does want to pass it, but this is a time where if you have concerns about the way this may work and operate your business, then this is a time when you should organize and speak out. because there was no public consultation on AIDA. It is taking a very specific approach to regulating artificial intelligence in this country. It's going to cover some things for certain, but there's some real questions about whether it's going to promote innovation in Canada and adopt a regulatory approach that's a systems approach, a sector approach, or approach that is as I started before, is more of a point system. So I know I'm out of time, so I'm going to stop because I believe, Jen, we might have some questions.
Yes, I was going to kick off, but yeah, if there was anything else, Barry, that you kind of wanted to finish in your thought to please do if you wanted to have another moment, just so you're not cut off.
Yeah, no, I realize that there's so much here, and in a half an hour, it's just impossible to cover everything that's going on.
Yeah.
But I do think the whole ecosystem, from the developers, the funders, the regulatory authorities, the advisors, the whole ecosystem that's involved in the in the digital supercluster really has to take a look at what's going on the AI ethics side for all the reasons that Carol had mentioned, and then it has to also keep an eye on what's going on in the regulatory fronts, and needs to be proactive on this, the design development of products, as well as proactive politically. Because what's happening is going to have very serious implications for the ability to innovate in this country. And if we have standards in this country that are far higher than in our main trading partner, United States, or far higher than the European Union, I think that while we may be at the forefront of AI regulation, we may also be at the forefront of potentially inhibiting innovation. And it's the balance of trust and confidence in AI, which is what Carol was articulating, which is immeasurably important, versus doing it in a way that's actually going to accomplish that and promote innovation, and do it in a way that's going to enable AI innovation in this country. And that's a big concern I have. But for people who have to get to the, what do I need to do, right? You got to do everything Carol said, and then you have to also watch what's happening and make sure you develop your AI models and governance to comply with the laws and regulations in Canada, in the EU, and the other countries where there are developments.
Thank you, Barry, and a great segue as well. Just before Carol has to hop off to another call, is a little a la 60 minutes. Carol, sort of some final words, last words to the audience to kind of close us out would be great.
The concept of AI regulation has been around for years now. So the fact that we are starting to see that the concepts and the concerns be prescribed and articulated into some form of written text is of no surprise. In addition, the way the law is, what the law is focusing on and what principles are focusing on, or standards, is not surprising. So when you take the entire presentation, sit back and with a good glass of wine, just really think about it, what you'll see is that you've got, regardless in the end of what the law specifically says, I agree with Barry 100%, keep your eye on it and participate. But we can already see what we're protecting against and what are those mechanisms we need to put in place to establish trustworthy, responsible AI as good, sort of innovative corporate citizens. So I just want to leave with that to say, go forth and conquer, do so responsibly. You already know how to do that.
Thank you so much, Carol. Carol and Barry, and before I hand it back to Ben to close us out, just on behalf of the entire community, really appreciate you carving out time. I know how tremendously busy you are, and so to share these insights has been incredibly invaluable to everybody. So thank you both again so much, and we reckon that we shall see you again in the future. And I'll let Ben close it out now. Thank you so much.
Thank you.
All right. Thanks again, Carol and Barry and Jen. And thank you everybody for attending as well. I will leave the Q&A open for a few minutes here, just in case anybody does have any questions that they want to type into that box, and then we can address them in a follow-up email for everybody. But again, thanks so much for attending, and I hope everybody has an excellent day.
Thank you. Bye all.
Take care. Bye.
Thank you.